Yes, no friend. Contact whose information you knew to be false and calculated to punish and discredit the reputation of one David Langat. Is it so not true?
Before he pleads, it looks like there's a mismatch in the charge sheet, and that it may not be worthy of pleading to it. So you'll be asking him to reject it under 89. If you look at the charge sheet and the particulars, if at all any name was to be punished, probably it would be that of William Ruto, if the particulars were not true. It would not be the name of David Langa. So what is the fear of putting the name of William Ruto as the complainant? This is a very, and you can see, I don't know how it has been drafted, but if there was a name to be tarnished here, the person who is looking like ungrateful and not quite a friend would be William Ruto. So I'm urging the court to read the charge carefully and reject it, because it doesn't, something is not adding up in this charge sheet. Even if we go to trial on this, and even if David Lagat comes, it will not be sufficient without William Ruto as a complainant.
Yes, Your Honor. Just to be precise on what you answered. Yes, just to be precise on what the senior counsel was submitted on. There is no doubt that the particulars of a charge sheet must be able to inform the accused person what he or she is pleading to. And that the particulars of an offense as and that the particulars must speak to the alleged offense. They must clearly square out the subject of the complaint to which our client has been brought to you to plead is one Mr. William Ruto. And therefore, if the offense as drafted does have any meaning in law, to the extent that our client is able to respond either positively or negatively, the particulars must relate to the subject. To that extent, Your Honor, this charge is defective, it's not worth the paper it's written on. And our client is not able to leave it as the particulars do not inform on how he should leave. It does not disclose who is the complainant. Is the complainant Mr. William Ruto, or is it P.L. Langat? And this is so important, Your Honor, and fundamentally important under Article 50, in the sense that we shall be requiring the statements of the complainant at the trial or at the fullness of time. So if a charge sheet is jumbled up as it is, Your Honor, it's only causing embarrassment to our client and to this court. That's for you.
if I may.
Yes,
Your Honor, if I may, the church brought before you this afternoon, Asha.
and so that we don't take a lot of time on this.
Yes, I'm only raising one
Just
issue.
request that we don't repeat what we are
Yes,
asking.
yes. I'm only raising one issue, that the alleged complainant here is also not a witness. I am wondering how the two police officers will be the witnesses in this matter. Yet the complainant is not. So I humbly submit, like my seniors before me, that this is a faulty charge sheet and should not see the light of the day. Thank you.
Your Honor, I will make a very short statement.
Yes,
Willis Otieno. An accused person under Article 50
Yes,
Under Article 50 of the Constitution, an accused person has a right to be informed in sufficient detail of the charges proposed against him. Sufficient detail. What is presented as a charge sheet if you look at the count 1, it talks of cyber harassment. But look at the particulars. That is where the devil lies. And where the devil lies, it sets out a purported ex post, but proceeds to show you where he's sleeping. Content whose information you knew to be false and calculated to tarnish and discredit the reputation of one David Lagat. This speaks, Your Honor, to a question of reputation, not harassment. And if it is reputation, it's defamation. If David Lagat or William Ruto thinks that this post has injured their reputation in the eyes of right-thinking members of the society, their recourse is in the civil court. They sue for defamation. And criminal defamation is no longer applicable in our legal system. So that if the particulars presented before your Honor
Mr. Otieno,
yes.
we don't know that there could be reporting this one with blood pressure. So you need just to check on your voice so that you don't
And become like a butterfly. I know sometimes I sting like a bee. Let me try to be the butterfly video. I'm not a jet. The particulars disclosed in the charge sheet speak to defamation, which is a civil wrong. The count in the charge sheet speaks to cyber harassment. There's disconnect in the two. So will Mr. Morara be required to respond to the count of cyber harassment or the particulars of defamation? That charge sheet, Your Honor, should not be registered at this particular point. And the state can advise the complainant that in relation to reputation, the Chief Magistrate's Court Milimani exists, civil division. You can go there. In relation to cyber harassment, the complainant should come with better particulars, not these ones. So having dissected those two, the particulars of the charge and the count on the charge sheet, Your Honor should exercise your discretion and refuse to register this charge as presented before you, and direct that Mr. Morara to be set free forthwith, unless otherwise lawfully detained. So this is prejudicial at the outset. That's all.
Very, very kind permission. Just a moment. If I write everything, if I say the whole thing,
That's what justice is out. That's what it means.
that's the challenge with us lawyers. We respond to what we don't know. We don't know what we're going to say. So I'll be writing manually because we have not set up the gadgets. We didn't know this case of this kind of coming today. So now just for your information, because now the gadgets have been set up, I will now not be writing. But please, when you speak, say your name at the beginning and use a microphone. So we'll have them transcripted.
The very kind permission in the matter is Morara, and I wish to grant the court's statement. I'll pick it up from where my learned senior Mr. Otieno left it, and urge us to go straight to Article 25 of the Constitution on rights that cannot be limited, Your Honor. One of the rights that cannot be limited, and while all other rights can be limited, is the right to fair trial. That is under Article 25C of the Constitution. Very quickly, Your Honor, I will, with the ability, invite the court to read that together with the provisions of Article 52B, which my learned senior, where my learned senior left. 52B, is about the right of the accused person to be informed of the charge with sufficient detail to answer it. But, what has come out in the few minutes before, 50 Article 2B. If I'm not wrong, it talks about what fair trial, all that is under Article 52, from 2A all through to 2, I believe, J. 52A all through to 50Q, Your Honor, is what constitutes fair trial. Such that, you know, we stand before you this morning or afternoon, the accused person is clearly not able to understand, Your Honor, what is responding to. This is a provision, Your Honor, or this is a right, Your Honor, which cannot be limited. I invite court to find basis on those two articles, Your Honor, to reject the charge that have been read out. That's all from you.
Yes, Your Honor, I just wanted to say one or two things. Yes, Your Honor, my name is Eric Uri. Your Honor, you've been referred to articles to refresh what has been stated. But Your Honor, so that you are not told that this court cannot deal with the questions of constitutional interpretation, Your Honor, I also wish to refer this court to the Criminal Procedure Code, and I would want to make reference to sections 135 with regard to the framing of charges. Section 135 with regards to the framing of charges. And Your Honor, it underpins the constitutional requirements that an accused person is entitled to sufficient information to be in a position to respond to the charges that are made against that person. Your Honor, second, you have the jurisdiction and the discretion under section 89 of the CPC to decline these charges if you are of the opinion, and Your Honor, we persuade you to be of this opinion, that the charge sheet before you does not, in sufficient material, disclose a case to enable the accused person to take a plea. Your Honor, I'll finally say, and I think I have said this before, if we continue at this rate, we will have to seriously expand this course.
However, when you read the particulars of the offense, specifically line 4, knowingly without lawful cause, knowingly without lawful excuse, posted false information. That is another offense under the Computer Business Act. Specifically section 22 of the Computer Business Act. If you go on further on, they repeated the statement, false again. And then lastly, finished with calculated to tarnish and discredit. Calculated to tarnish and discredit the reputation of one David Morara. So, Your Honor, in brief, the question is Morara answering to the charge of cyber harassment or to the charge of publishing false information or civil or defamation? Your Honor, in brief, as I associated both my learned senior counsel Eric Thori stated, I was with Morara when he was being arrested. The police refused to grant me access to Article 49, and there are orders that have been given by the High Court that the police ought to respect and ought to follow Article 49 of the Constitution. Some of those orders I personally obtained them from the High Court. Additionally, they did not disclose why they were arresting him or who they were. Some of them were masked. So, Your Honor, the question is, we are dealing with people.
Sorry. We might all of us end up fainting here. So please, just a request that you allow me to manage the crowd. But request everybody after the gentleman in the big camera. We are just going to ask you kindly to step out of the room. Otherwise, we don't want to stay. Please, you can listen from outside. We have speakers, so you'll be able to listen. So now, if you have problems with that, we just have to break. Because head comes first. Please. But I want to see you counsel speaking.
Oh, yes, Your Honor. So,
because you can get so many of us are sweating. You can get the smell of sweat. But it's really long.
yes, Your Honor, I'll be brief. Your Honor, in
How many more minutes will you take?
3-4 minutes.
Okay, please.
Your Honor, in brief, what we are witnessing here as a country is the weaponization of the criminal judicial process against a young man who, against all odds, stood up to speak the truth. And the truth has hurt many people who are currently in power. That truth has altered the status quo.
Sorry, you are not a witness. You are yet to take leave.
But in brief, Your Honor, history is being made, and I invite this honorable court to stand on the right side of history by quashing these charges and releasing the accused person on personal bond. He is a young person, he is a young person. To release, to free him, to discharge him. And lastly, as his personal lawyer, I want to thank him for actually believing in a young person. Fellow Gen Z, and we will stand with him together.
May the court afford exactly 1.5 minutes. My name is Otieno Bradley. It's a privilege to appear before you, Your Honor, in this matter. And just to add to what has been said, the constitutional justification for the cause of action we are requesting you to take. If you look at Article 24, it is a balancing act that the court must strike. And the court must look at the least restrictive alternative. In this case, Your Honor, there is an alternative for the complainant. That alternative is called the Defamation Act. It's sufficient to address any reputational damages. And so there will be justice for the complainant, whichever, if you make the decision we are requesting you to make. And the other one is in Article 23A. That article obligates this court to adopt Article 20 Subarticle 3A. You know, this court cannot interpret the Constitution. That jurisdiction belongs to the High Court. However, this court, as a constitutional organ, must apply the Constitution. And when you look at Article 23A, it requires this court and all tribunals to adopt the interpretation that most favors the enjoyment of rights. In this case, Morara's right to freedom of speech, especially on the issues he's speaking about. So, Your Honor, there's sufficient legal basis for you to find that this charge does not disclose a criminal case, and that the remedy, alternative remedy of defamation is sufficient. Thank you so much.
Your Honor, perhaps before the prosecution responds.
Just a minute, Mr.
Freediving for me is leaving the world to see the most incredible world there is.
Only one about the charge sheet, because it will become relevant for them in response. Only one. Perhaps, Your Honor, to just disclose the bad faith in which this matter has been instituted. That the charge sheet itself is indicating erroneous dates when our client was arrested. We say that they arrested him today. And the fact is that they arrested him yesterday. They have a duty to disclose all the material facts, and there is a reason why the CPC requires a date of arrest to be indicated on a charge sheet. Eventually, Your Honor, when you seek to retire, kindly order the DCI office, and this is the DCI himself, to release 3 phones and 1 laptop belonging to our client, as we discharge him. Most obliged.
Even though we just have a brief response, maybe to just start off, it's the first time I'm seeing Mr. Ndegwa and Jiru very calm. It is unlike him. Your Honor, just in brief response, in terms of arrest, it's true the accused person was arrested yesterday and has been produced in court within the required time limit.
Your name for the record?
Undimu. And has been produced in court within the required time limit. In terms of access to counsel, I did confirm with the officers that he was allowed access to counsel, and the counsel who was allowed was Mr. Ndegwa and Jiru. And in fact, Mr. Ndegwa and Jiru did appear at our office today morning. And we confirmed that the charge sheet will be brought. He was accompanied by 2 other counsels, though they declined my invitation. Your Honor, in terms of the charge sheet, the CPC is very clear that a charge sheet must contain 2 critical elements. That is the statement of the offense and the particulars of the charge. Your Honor, my colleagues, my senior colleagues and junior colleagues have not disputed that there is a statement of the offense and the particulars. The contention, especially my senior colleagues have raised, is what is harassment? Your Honor, I look at that particular act, the Computer Nuisance and Cyber Crimes Act. It does not in any way define what harassment is. Harassment takes various forms. For one to draw a conclusion that harassment has occurred. The particulars in the charge have clearly informed the accused person of the accusation that he is facing. And what my colleagues are asking you to do is to go to the substance and the merits of the charges, to go to the evidential material. As at this point, Your Honor,
Just one.
As at this point, what court ought to consider that the particulars of the charge have sufficiently informed the accused person of the accusation against him, which in our humble view are sufficient to enable him respond to the charges. To delve into other issues, Your Honor, would be going to the merits and demerits of the particular matter. I do understand the constitutional issue that have been raised by my senior colleagues. And those issues cannot be raised as at this point. The only purpose we are here for today is purposes of the charge sheet, whether it has statement of the offense and the particulars of the offense, and other considerations. Refer this court to section 137 of the CPC. Your Honor, on the last point that Mr. Ndegwa has raised, on the issue of the 3 phones and 1 laptop, I undertake to follow up the issue with the investigating officer to find out if they are interested in the material or the same should be released to the accused person, and undertake to inform him before the closure of business today as to what the response of the investigating officer has been. Luckily, I have Mr. Ndegwa's number. And also Mr. Eric Teuri. Surprisingly, the squatter from Tuapa has not spoken. I'm sure he will respond.
Your Honor, I have been invited by my colleague from the